Hello and welcome to the NBL seminar on the rules on UK and EU vertical agreements, the EU block exemption explored. My name's Robert Bell, and I'm going to be taking you through an exploration of the EU block exemption and how they apply to vertical agreements today. I'm a founder director of BCRS, a legal consultancy supplying competition and regulatory consultancy services, and I also act for a number of law firms in that capacity. I have 30 years experience of advising on complex competition and regulatory matters, both in London and Brussels, and I advise on a range of competition issues relating to merger control, cartels, restricted practices, and also distribution issues, which we are looking at today. So what are we going to be doing today? Well, essentially, the primary focus of the webinar today is the application of EU competition law to vertical agreements, with a particular focus on how to get your vertical agreement within the safe harbour legislation of the EU block exemption regulation, and why it's important to do so. Post-Brexit, both the UK and the EU have separate competition law jurisdictions, and so we'll be looking at the UK version of the block exemption on vertical agreements and how it compares to its EU counterpart. And then we'll be looking at how the block exemption applies to common restrictive terms in vertical agreements, and in particular pricing, internet selling, territorial and customer exclusivity, non-competition restrictions, and finally best price, most favoured nation clauses. And we'll be looking at those, the rules, and exploring how they apply in practice with a few simple case studies. And then we'll be rounding up with a few key takeaways.